Now call the first case on this morning's docket. That is case number 104644, Melanie A. Fisher v. Alex F. DeCarabalho. Help me with this, counsel.
DeCarabalho.
DeCarabalho. Thank you, MD.
David R. Morantz on behalf of Plaintiff Melanie Fisher. May it please the Court, and I'd ask the Court's permission to reserve 4 minutes for rebuttal time.
5 minutes is granted.
Thank you. As this Court knows, this is a question involving service of process upon a defendant in a medical negligence case. A plaintiff attempted service on the defendant in December of 2009 by sending service of process by certified mail to the defendant's office. Defendant objected and raised a defense of insufficient service in January of 2010. The District Court dismissed this action in April of 2010, and the Court of Appeals upheld that dismissal in 2011. The main issues before this Court today, and the two arguments that I'd like to highlight, are whether a plaintiff was in substantial compliance with the service of process methods under 6204, and if not, whether plaintiff should have been afforded an additional 90 days under 6203B to reserve the defendant. We certainly acknowledge that service was not perfect. However, we argue that we substantially complied with the methods of service, and therefore it should be proper under 6204. Alternatively, if this Court does not agree, we argue that we should have been afforded an additional 90 days to reserve under 6203B, and that's probably going to take up the bulk of the discussion today.
Counsel, no service was ever attempted at the home of the defendant, correct?
That's correct, Your Honor.
So how does that substantially comply with the business service? Because isn't that required as a prerequisite?
Yes, I would agree with you that on its face, it did not comply with serving the defendant at his home address. We would argue that because he was notified of the suit, that it substantially complied with 204.
But our cases indicate that you have to have substantial compliance before you look at whether there was actual notice, don't they?
Yes, you're correct.
Okay.
And
that's a hard point for you.
It comes down to how you define substantial compliance, I think, is the nut of this issue. And I would argue...
In this regard, you would agree that not only did you not attempt service at residence first, but you didn't file the return that said refused or not claimed at the residence, and you didn't follow up with a restricted mailing to the business office, and you didn't ascertain whether Phyllis that signed for it was in fact an agent authorized to accept service. And so there may have been actual notice, but there's nothing on paper that would indicate that the doctor ever got this or that it was really designed for him to receive it.
Well, I would agree with you by the facts you just recited. Getting back, though, to what defines substantial compliance and whether the doctor was afforded notice of the lawsuit, the Court of Appeals, in the opinion under review, said that 204 does not define substantial compliance. This court defined substantial compliance in the Myers v. Board of Jackson County Commissioners case in the context of a 12105B claim against a municipality. But I would respectfully disagree with the Court of Appeals opinion below and argue that 204, by its plain language, self-defines substantial compliance. It states that substantial compliance, in essence, equals valid service if the party served was made aware that an action or proceeding was pending in a specified court that might affect that party. So I'd argue it's a self-defining statute. Here, there's no indication that the defendant was not made aware of the suit through the service. He turned the suit over to his attorneys. They promptly answered. They obviously knew about the service. They were handed it, and they were afforded a chance to argue that it was improper. So I would argue that he was afforded notice of the suit. It wasn't substantial, and we are in substantial compliance with 204.
But doesn't 204
you're reading 204, the term substantial compliance to be self-defined, but the term substantial compliance appears to refer to the clause immediately before it. In any method of serving process, comma, substantial compliance therewith, meaning with that method of serving process. Then it says that shall, if you substantially comply with that method, you shall effect valid service of process if, and then it has these additional requirements. It seems fairly clear that way.
Well, and you make a good point. I think that was part of the issue that prompted this court in the Myers case to state that substantial compliance means compliance in respect to the essential matters necessary to assure every reasonable objective of the statute. The reasonable objective of the service statute is to put the defendant on notice. We are arguing that we did that through the service, even though it wasn't perfect, and therefore it substantially complied. I'd like to move to the next argument, 6203B, and here it was not briefed, or it was not referenced in the briefs. It was an opinion that came down in 2012, and I'm going to be referring to it frequently throughout the arguments today. But that is the case of Kuhn v. Schmidt, 47 Can-App 2D 241, specifically a very forceful and strong concurring opinion written by Judge Atchison. In that concurring opinion, Judge Atchison pointed out the errors of the Grimmett test, which I'll get into in a little bit, and makes a forceful argument for why in cases such as the one we are arguing today, plaintiffs should be given additional time to perfect service under 6203B. As the court knows, 203B provides that if service is adjudicated to be improper, the plaintiff can be afforded an additional 90 days to reserve, and the plain language of the statute is critical here due to any irregularity in form or procedure or any defect in making service. Now, that was the 2009-2010 version of the statute. It was slightly changed in 2011, but the substance of the statute remains the same. The plain language of 6203B, however, has been greatly stripped down by the Court of Appeals through the Grimmett v. Burke case, which is referenced in our briefs. And that Grimmett test was adopted in a rather odd fashion, as Judge Atchison pointed out in the Kuhn case, by this court in the Perrin-Abbott versus Kansas Department of Revenue case. As Judge Atchison wrote in Kuhn, the Grimmett test placed a, quote, judicial gloss on a statute that was enacted to prevent the very type of dismissal that we have here today. He also referenced that those three factors under the Grimmett test were pulled out of thin air. And if we get into those three factors, the first is whether service appeared to be valid. And this is really the heart of Judge Atchison's opinion in the Kuhn case and the heart of our argument today. Getting back to the history of 203B, there were a couple cases before the enactment of 203B, specifically the Dunn and Briscoe cases that are also referenced in the briefs, where service did not appear to be valid, and those cases were kicked out for improper service. 6203B was then enacted, and the case is referenced with the legislative intent of preventing the very types of dismissals that you had in Dunn and Briscoe. Now, critically for the Court of Appeals opinion below here, they stated that the service that we attempted in this case did not meet the first factor of the Grimmett test because the service did not appear valid on its face. As Judge Atchison pointed out, and as we are arguing forcefully today, the plain language of the statute mentions nothing that the service needs to appear valid on its face. The legislature certainly could have done so and included that language if it had desired. Rather, it said that the service must purport to have been made, which was defined by this court in the Hughes case as having the appearance of being. And as Judge Atchison pointed out, if you look at the language of the Grimmett case and the logic of the panel of the Court of Appeals below in this case here, the Dunn and Briscoe cases would have been kicked out even under the Grimmett test. The very cases that were the reason to prompt 6203B would have been kicked out under the Grimmett test that reads too much into the plain language of the statute. As this court knows from the Bergstrom case going forward, this court has directed courts below to take a hard line on examining the plain language of the statute, saying that a court will not speculate on legislative intent and will not read the statute to add something not readily found in it. If the statutory language is clear, no need exists to resort to statutory construction. We would argue that that is exactly what the Court of Appeals did in the Grimmett case. This court needs to kick out that Grimmett case to do away with the Grimmett factors because it's read too much into 6203B and pulled factors out of thin air that plainly aren't there. The next factor under the Grimmett test is whether the plaintiff relied on the belief that service was valid. And actually, the Grimmett court added in the phrase, relied in good faith on that belief. Judge Atchison, as he pointed out in the concurring opinion in Kuhn, there is nothing in the statute about a good faith belief in that. And he pointed out another interesting point here, that the legislature intended by 6203B to protect plaintiffs and litigants from technical missteps that can be readily corrected and that do not impair a defendant's ability to respond on the merits. That's exactly what we have here. Service was not perfect. It was a technical misstep. It can be corrected simply by affording plaintiff additional time to reserve the defendant. The defendant has not been prejudiced. The defendant has been able to defend this case on its merits, and I'll reserve the rest of my time and arguments for rebuttal unless there are any other questions.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
May it please the Court, Trevin Ray on behalf of the defendant, appellee, Dr. Alex DeCarabalho. One thing I want to make sure I address from the outset, Fisher, the appellant, really can't contend that the district court or the Court of Appeals erred in this instance because the district court and the Court of Appeals followed direct and binding precedent in reaching their decisions. What Fisher really asks this court to do is to abandon decades of precedent and to abandon and to overturn those decisions and find in this case that substantial compliance essentially equates with no compliance whatsoever. And that is the key problem with this.
That's what the statute says.
Excuse me?
The statute says, 6203B does say that. It says any defect or any problem.
The substantial compliance statute says that if you have used a method of service and have substantially complied with that method of service, then service may be deemed valid.
I think you're talking past each other. Statutes.
Right.
He's talking about 203B.
Right. The first part, they're arguing the substantial compliance portion of in the primary argument. 203B is essentially you get another chance at service if service purported to be made but then was deemed later technically invalid or something of the like.
And why does that not apply here?
Because in this case, under the plain language of 203B, there is no meaning of the word purport could be applied to this case. There's not been any service of Dr. DeCarabalho at all.
And no meaning of purport as in Black's Law Dictionary?
Right. Purport is defined as giving the appearance of.
Well, that's one of the definitions. It goes on to say, quote, the professor claim, especially falsely, to seem to be the document purports to be a will, but it is neither signed nor dated, is the example. And why isn't that exactly here if the document purports to be a will, but it's not technically correct? It's the same concept as the service indicates that it was served correctly, but there were technical difficulties.
I would take two issues with that. The first is that the service was by certified mail, and so the process of service did not.
We're talking now, what does purport mean? And why wouldn't we apply the alternative definition of purport.
And what I'm addressing is that it could not have purported to be made for two reasons. One is because it didn't follow the service statute on process. So he's sent certified mail out to a business address without attempting residential service, without filing an affidavit that says the return was unclaimed or refused. And then, more importantly, it's not signed by Dr. DeCarabalho, so there's no restricted delivery. There has not been any service of Dr. DeCarabalho. It's been signed for by someone else who's unknown at the time. So under any definition of purport to be, no one can look at that return and say, that appears that I have service on Dr. DeCarabalho. That does not allow for that inference under the loosest definition of the term purport. And that's the main issue here. There's much made of Grimmett, but the court really doesn't need to reach any analysis of Grimmett, and that's what the Court of Appeals focused on, and what we argued about at the Court of Appeals level is that regardless of whether these elements that are set forth in Grimmett are even touched, the plain language of the statute does not allow for a quote-unquote second chance at service under these conditions, because there's nothing that would allow any person to objectively think that they had service, but then it was later rendered technically invalid.
I guess I'm a little confused about the Grimmett factors and the why they're necessary. If it appears to be valid, there's a good faith belief that it's valid, and all those factors, that would seem to me to be substantial compliance with the statute. And if there's substantial compliance, then it's valid by 6204, and you don't need to get to 6203B to fix an invalid, because substantial compliance is defined as valid. You understand what I'm trying to say here?
I do understand. That question specifically I don't think has been reached, and it doesn't have to be reached in this case either, I don't believe, because Well,
it does if we're going to revisit Grimmett.
Well,
if we're going to say that the Grimmett factors don't comport with the plain language of the statute, and in fact destroy legislative intent of 203B by making correction only valid if it is valid. It can be fixed if it's already valid. And if we decide that, then it does affect this case.
I would say it doesn't, because initially, as I said, it doesn't appear valid. So that much can be, the issue then can be put to bed. But I would defend this notion of the Grimmett court, the elements being pulled out of thin air. I don't believe that that's the case. And this court also adopted those elements. What the Grimmett court was faced with is that there is a statute that says you can have a second chance of service with a technically invalid first attempt at service. But what the legislature did not do was give free license to just ignore the service statutes altogether.
How do we know that?
Well, because they didn't repeal any of the service statutes. If the legislature could have repealed all of those mandates on
But they're not mutually exclusive. What 203B says, 204 says here's how you do it. 203B says if you didn't do it the first time, you get a second chance.
I do not believe that's what 203B says. 203B says you first have to have purported to make service on the first attempt, and you have to, the only way that you can purport to make service is by following something that is set out by the legislature, some dictate on service. This court has said repeatedly that it will not create new methods of serving process that supplant those already provided by the legislature. So 203B cannot be reconciled as some broad, all-encompassing do-over, no matter whether you tried to comply with the statutes the first time or not.
Sorry, go ahead with your answer.
I'm sorry. So I do think that the Grimmett court was faced with reconciling that statute, and I think that the biggest argument in favor of the fact that the Grimmett court got it right and did in fact adequately represent the legislative intent behind 203B is that 203B was amended in 2005, 2010, and 2011, 3 times after the Grimmett decision in 1995, and twice after this court adopted the Grimmett test in Perrin Abbott versus the Department of Revenue and never changed the substance. If the legislature felt that the Grimmett court had missed the issue or had read too much into the statute or had got their intent wrong, they could have changed it and would have done so, one would think. So I don't think that 203B can just be, the Grimmett factors can be discarded as improperly decided or pulled from thin air. I don't think that that's the case.
We know what actually happened in this case on the effort to achieve process, and it's your position that that does not meet 203B's requirement of purporting to have been made.
That's correct, Your Honor.
Can you tell me what the minimum extra would needed to have been done in this case in order to reach purported to have been made?
I think that at a minimum, one would have to comply with the process that goes into certified mail service at a business address. In this case, there was no first residential attempt. There was no filing of a return that was unclaimed or refused, as is required by that statute. There was no restricted delivery, which was required at the time, that would ensure that Dr. DeCarabalho did in fact receive the service. Those things, I think, at a minimum would have to be done to demonstrate that you have, that service could have been purported to be made, because it has to be
But if they'd done all of that, we wouldn't be here.
Right.
So what's the purpose of 203B?
I think that what I envision 203B is, so let's say that you attempt residential service and there's a portion of the residential service statute that allows you to leave a copy of the summons and petition with a person of suitable age. If it later turns out that the person was not of suitable age, there's a technical irregularity and you would have thought that you had accomplished service.
Does purport mean something different than substantial compliance?
Yes, it at least gives the appearance that you had service.
And it has to, because if you have substantial compliance and awareness, and we all agree we have an awareness here.
We do.
Yeah, okay, that you would have valid service. So purport is different than substantial compliance. And tell me, in this instance, when you went through first do residential service, then file the return, then send restricted, then ascertain authorized agent, how much of that would need to be there to be substantial compliance, and how does that differ than being purported? You understand what I'm saying?
I do. I understand the question. I don't know that we can truly analyze that in this case, because it would be purely hypothetical. In this case, none of them were done. And so what I can say definitively is that when you do none of them, it's hard to argue that you have substantially complied. When it speaks of substantial compliance, I think it refers more or less to following the procedural steps outlined in the code. I mean, it's important to recall that this is an issue of personal jurisdiction. This court, and probably every other court in the country, has stated that you only achieve adequate personal jurisdiction through proper service of process. It's a substantive issue, not one that's taken lightly. So if you're going to say you've substantially complied, one would think that you'd have to do something that complies with the statutes that dictate the manner and method of service. And so I suppose it's easy to have it's difficult to have an academic discussion on what cases could we envision would provide us with a set of facts that would in fact.
But we have to in fact do that. We have to decide whether Grimmett equated purport with substantial compliance, and if so, then it rendered 203B useless, because if the only way you can get a cure is for an invalid is if you establish that it was valid in the first place, then you don't really have a cure, do you?
That's a different analysis. The substantial compliance argument that they're raising is brought under 6204, which is...
I understand that, but we've established now there has to be a different... Purport must mean something different than substantial compliance. We agree on that, do we not?
I guess I haven't really reached that question, because I have trouble getting by two things when I address each of those things individually. One is that the term substantial compliance in this case couldn't apply anyway because there's not been any compliance. And I can't get by the fact that purport to be has to mean something. It can't mean has no appearance of. So it has to mean that there has been something that would suggest that service looked like it was made.
But we can agree that purport has to mean something less than substantial compliance.
I guess I would have to go that far.
It would have to have any meaning, right?
To have some application, that is correct. I think that substantial compliance is more about the method that's used versus the appearance of, but that's but the two arguments are distinct. I just want to make sure I have that set out. The 6203B analysis is the Grimmett test. That's where Grimmett was decided. Those elements were in response to having to try to reconcile the fact that that it says if service purports to be made, but there's a technical irregularity, that there is going to be a 30-day opportunity to reserve. That can't mean that there's just an opportunity to reserve in every case. Otherwise, the legislature needed to repeal the service of process statutes, which are very lengthy.
Well, you have me confused because you said substantial compliance would be the circumstance where there was just a technical failure, like the person receiving wasn't old enough, and if that's the case, that's substantial compliance, and now you're saying that's also purporting. So I'm not seeing where you're making the distinction.
Well, the substantial compliance is with a method. It's with the method of serving process. You could have service that purports to be made in a variety of instances, like if Dr. DeCarabalho had signed this return, okay, let's just say that, but they had not failed, or they had not attempted residential service, they had not filed their affidavit, they hadn't done restricted delivery, but by some coincidence, Dr. DeCarabalho signs the return and they had reason to believe that they had service. Then we're getting into the substantial compliance with a method analysis.
I'm sorry, I keep cutting you off. Please answer.
That's okay, Justice. I'm done.
Okay. You've talked about the plain language of 203B, and we've spent a lot of time talking about what purports mean. I'd like to go to some other language in that statute, and it says any defect in making service.
Correct.
Tell me why that is not what we have here.
The predicate paragraph is ignored in that analysis. That is the argument you've correctly identified. That's the argument that Fisher makes. But the predicate sentence is ignored in that analysis. It's the first sentence is, if service of process or first publication purports to have been made, but is later adjudicated to have been invalid due to an irregularity in form or procedure or defect in making service. It does not say that any technical irregularity or any irregularity in form or anything like that, that is automatic, that any service that's deficient gets a do-over. It says first that the service has to purport to have been made. And that gets back to my overriding point, and that is that if you don't read it that way, then there's no reason for any plaintiff to ever abide by the service statutes at all. And because you always get a do-over. And that, I think, is the issue. If the legislature did not put that first sentence in, we might be having a different argument. But the legislature clearly dictates that service has to purport to have been made.
What do you think the statutory objective is to the service of process?
I apologize, Judge.
What do you think the statutory objective is to the service of process statutes?
A proper invocation of a court's personal jurisdiction.
To the defendant?
Correct. If there are no more questions, I have...
I want to follow up on Justice Biles. It seems to me that the legislature has hinted, at least, at the purpose of service of process when it speaks in 204 to the party served was made aware that an action or proceeding was pending in a specified court in which his or her person's status or property were subject to being affected. And that's due process, notice and opportunity to be heard. And personal service is a due process issue, is it not?
It is.
And the legislature has talked about complying with due process by making the party served aware of which court they have to go to and defend what. And in this case, that occurred.
So Dr. DeCarabalho showed up to court to specifically assert that service was improper, not just insufficient, by the way, which was stated on the appellant's argument, that service was improper, and he has the right to do so under 212H. It's a specific right to do so. So this notion that if you show up, you have to assert a specific right, you have in fact waived the right, is paradoxical to me. The defendant shouldn't be forced to risk contempt.
That's not what we're talking about. We're talking about what is the whole purpose of having these service of process statutes delineating the method. And I'm saying that it appears here that the purpose is to get the notice into the hands of the person that has to defend himself or herself or itself.
To have proper assurances that personal jurisdiction is adequately invoked and that the defendant is given a right to due process. But if it's just that it happens somehow, regardless of how that is, then we don't need service statutes at all. 212H should not have a defense listed in its defenses that allows for an objection to process. The legislature has done none of those things, so I do not believe that.
But that's not true here. If the woman that signed, Phyllis, that signed for this, didn't give it to the doctor, and he never knew about it, and there's a default judgment, that gets set aside.
Maybe. But I think that we know that procedurally there are improper, there's a risk associated with saying the only way I can assert this right is to not show up, is that you then put the burden on the defendant instead the plaintiff then has.
That's not what I'm talking about. I'm not talking about the special appearance or general appearance. I'm not talking about that. I'm saying that there's a purpose to delineating methodology here to assure notice, and to say that if you get notice you can ignore non-compliance then obliterates the purpose of the service statute. I don't buy that. The purpose is to get the notice, and if it is effective, then good.
If that's the case, then the legislature would not have 6303 at all. The 303 is a lengthy statute that talks about the methods of serving process. It should simply say you have to find some way to make the defendant feel like he needs to come to court, period. And it doesn't say that. And the legislature does not invoke meaningless statutes. There's a method that you have to follow, and if you don't follow it, the defendant has a right under 6212H to assert that you didn't follow it. And Dr. DeCarabalho did exactly that. He came to court to say, you didn't serve me. And the argument here is, well, I must have served you because you showed up to court, and that's paradoxical. It's not Dr. DeCarabalho's burden to demonstrate that the plaintiff has improperly invoked jurisdiction. It's the plaintiff's burden, and that's the core of the argument.
But why isn't that enough to be able to invoke the 90-day grace period if there's a defect?
The 30 days to reserve?
Yeah. I'm sorry, I said 90, but I meant 30.
Sure, understood. Because the statute itself says that service has to purport to be made.
Which gets you back to my question, because the reason I asked about the purpose of the statute is trying to draw an analogy to the municipality notices. We just issued an opinion on that this summer, which has a lot of case law that goes back, that really just says substantial compliance means to look at the reasonable objectives of the statute, and if those reasonable objectives have been met, then you have substantial compliance. And it seems to me that that's not a bad analogy. And so it separates the situation where the plaintiff puts the lawsuit in their desk and then claims to get service. I mean, they actually got notice to your guy, and he showed up. But there's a problem. There's a defect. and then you give that period of time to correct the defect, and you move on.
Well, the core of your statement, though, is that there is substantial compliance, or that there is some effort, right? That's the whole.
No, that the reasonable objectives of the statute have been met, and that gets back to Justice Johnson's question about, the doctor got notice. He knew he could do something if he wanted to, and he did. And now we're just trying to clean up the defects.
Well, he had to come to court to assert that it was defective. Otherwise, he risks a default. And that gets back to my main point. The burden shouldn't be on Dr. DeCarabalho to risk an improperly entered default in order to assert a right he's specifically given by statute. So if the analysis is, if you get him to court, no matter how that happens, then you've met the reasonable objectives of the statute, and the statute should have nothing in it. It should just say, just get him to court. And it doesn't say that, because we want to make sure that people follow a process that is reasonably assured or to be reliable to get people to court. And that didn't happen here. And if we're going to say that if you just get them there, you can ignore the statute altogether, that for sure undermines the intent of the legislature. And so that, I think, is where the argument keeps coming around and around, is that you can't equate substantial compliance with no compliance whatsoever. Service can't purport to be made when it didn't look like it was made at all. And that was the argument that was made at the district court and continues to be made.
Justice Biles, were you finished?
Yeah.
What case would you be primarily relying upon to say that service did not purport to have been made here?
I don't know that I would be relying necessarily on a case. The Grimmett case obviously set out the factors where they would set out what would purport to be made, but I would say on the plain language of the statute and on whatever interpretation there could be reasonably on the term purport to be, on the phrase purport to be made, it could not apply here because it was certified mail, not sent in compliance with the statute, and signed for by a third person. So that, I think, is why I say in plain language, and if you read the Court of Appeals opinion on this case, we got to that. We fought a little about Grimmett, but ultimately I kept coming back to you don't need to even look at Grimmett, and you don't need a case. What you have here is no service. So it couldn't have purported to be made because there's nothing that looks like it was ever made at all. So that's, I guess, it's a long-winded answer, I know, to a very short question, but that's really what it comes down to.
And it gets back to the discussion you and Justice Johnson had a few minutes ago about Black's Law Dictionary definition of purport, it sounds like.
Yes, Your Honor.
Okay.
Well, really, for that matter, any definition of the word purport. I don't know of a definition of purport that would allow you to conclude that not appearing at all is what purport means.
Okay. You have any further questions of counsel? Thank you, counsel.
I thank the court.
May it please the court.
Counsel, can you begin by telling me what facts you rely on to purport to have made service?
Yes. The service came back from the defendant's office. It had been received. We acknowledge that it was received by an office worker there, not by the doctor, but that it had come back. And also, I think the bigger factor and in the bigger picture of this case, and as I'd like to mention in a little bit, is that this litigation proceeded as in a normal case. There had been a defense raised of insufficient service. It was raised along with quite a few other defenses that are pretty standard in an answer, but discovery commenced. An answer was filed by the defendant. Discovery responses or discovery requests were sent by defendant. Interrogatory answers were signed by the defendant. So this case moved on in a normal manner, and I agree that...
Basically, you're saying that you acted as if you were alleging that you had service. You filed the return of service and just proceeded as if you had done it correctly.
Yes, and I would say that...
Which sort of fits the secondary Black's Law dictionary that you were purporting to have the document be valid, but it wasn't.
Yes, I would agree with you. In both parties proceeded as if service had been had. Both parties went on through discovery.
Well, they did what they normally would do, a defendant normally would do, and assert the defense and wait for you to do discovery on that defense, which you didn't do. You served interrogatories and requests for production and didn't ask about their personal jurisdiction defense.
The original discovery was provided with the petition, I believe.
But you had an opportunity after they filed their answer and asserted the defense to do the discovery like you normally would about any defense that they asserted.
You're correct.
If you had any question about why they said there's no service of process here, which is all they're obligated to do when they file their answer.
You're correct about that. However, the issue of raising the service of defense argument came up after the 90-day window to perfect service. That gets to the third factor of the Grimmett test,
Right.
is that the defense must be raised while the plaintiff still has a chance to cure process. We did not have that chance in this case. Had it been raised after that and pursued, and had we tried to reserve, it would have been after the 90 days, and we'd probably be back to the same place we are here.
So you just chose not to do any discovery on it.
No discovery was done on that. You're correct.
I am a little at a loss as to how we translate a defendant's actions to be a factor in purporting that service has been made. It seems to me like it is the plaintiff that purports that service has been made.
I think, Your Honor, that by the office being served and by the case moving on in a normal manner and defense is not just being raised but discovery being done and interrogatory answers being signed, that we thought that service had been had. We mistakenly thought, and we'll acknowledge that service had occurred and that the case moved on as in a normal case. I want to point that there's been good questions and good discussion about the purpose of 6203B. I'd urge the court to look at the opinion in the Hughes case that this court mentioned about curing any defect or any irregularity by the plain language of the statute. But more importantly, I'd urge the court to look at page 253 of Judge Atchison's concurring opinion in the Kuhn case, where he said that applied as written, 6203B avoids machinations. Plaintiff serves process, defendant responds, says service wasn't done right, district court decides. If it rules for plaintiff, that's the end. If it rules for defendant, plaintiff has 90 days to serve and the case continues. The plaintiff should be given the opportunity to correct the error without suffering a substantial penalty. And that's what we would argue we need to have done here.
I was going to ask him to follow up on the question you had asked, so why don't you
Go
start?
ahead, that's fine.
Justice Luker asked you a question to tell us everything you believe rose to the level of purporting to have had process made. And what I wrote down first was, well, it was received by an office worker in the doctor's office, and then you went into discovery performed by both sides, et cetera. So my question is there anything else that the plaintiff did affirmatively that you believe supports your case that process purports to have been made?
Process purported to have been made because the defendant was obviously made aware of the lawsuit, and the lawsuit continued. And beyond just paper documents such as the return coming back from an office worker, I can't point to anything in the record that shows that.
Did you file a return of service?
Yes.
With the signed receipt with the office worker?
Yes.
And you filed that with the court as if you were purporting to make return of service process?
Yes. Yes.
Would you say that actual notice is a requirement for the application of that provision? Of
the provision of 203B? Well, it depends on what you mean by actual notice, as in the summons actually getting into the doctor's hand.
Yes.
I'm not sure about that. I think that getting back to the substantial compliance argument and the objectives of the statute, if the objectives of the service statute is to make the defendant aware of an action pending in a specified court, if that defendant was made aware of that action, whether by the document actually getting into his hand, a copy of it getting to him, or somebody saying, we got this document, then service would purport to have been made.
But it wouldn't be enough if he just happened to read the legal notices or the filings with the district court in the paper and saw that an action had been brought, or would it?
I'm not sure, and I don't think we have any arguments or evidence that that happened in this case. Obviously, the doctor at some point received the summons because it was turned over to his counsel, and his counsel was able to assert a defense of insufficient service on it. So we know by what happened afterwards that at some point he got it.
I understand your argument in reconciling the two provisions we've focused on today. How does your argument reconcile with the provisions of 6212B that give you a defense to insufficient service of process? Doesn't your reading of the statute pretty much just repeal that defense?
No, and I think that I direct the court here to page 12 of our prayer for review and to a portion from Professor Gard's treatise on 203B that addressed this issue. And Professor Gard, in discussing this court's opinion in Hughes, said that the opinion in Hughes about 203B, he says, actually the decision comes close to saying that there was an entry of appearance by the defendant by his conduct through which he lost the benefit of his pleading of lack of jurisdiction. Nothing in 6212 would have prevented a defendant from making that pleading or that defense of insufficient service of process and stopping the game right there and going to the court and saying, we have invalid service, it happened now we're after 90 days, and we require dismissal of the case. That could have happened. But by what Professor Gard has said in his analysis of this court's decision in Hughes, looking at 203B, there has in effect been a waiver of the defense, but more importantly, it goes to the issue that Judge Atchison pointed out in the Kuhn case. The defendant has had a chance to respond to the merits of the case and to defend this case and has not been prejudiced by the technical misstep or the error in service.
But 212B would still apply if defendant didn't comply with 203B. You still have to go back and cure the error. And if it's not cured, then the mechanism by which that could be, the mechanism behind dismissal for lack of service is still there.
Yes.
I mean, the affirmative defense is still there. It's all 203B does is give the defendant a second, or a plaintiff a second chance to get it right.
Opportunity to cure.
Right.
Yes, that's correct.
But isn't there prejudice that arises out of the statute of limitations here?
Well, if the defendant is made aware of the case within the 90 days of the statute of limitations running, then I'm not sure how the defendant can claim prejudice from not being made aware or from being made aware after the statute has run.
Which gets back to the question of whether we need to say that the defendant's awareness is a critical component of applying the statute.
Well, I think that, and this is, it's interesting because we talk about this in the context of very specific procedural machinations, and it all gets to the issue of fairness and whether a defendant has been made aware of a suit in a specified court and has a chance to defend it. And if you look at what would happen had the defendant not received the summons, we could have at some point moved for for default judgment if we hadn't received an answer. And at that point, as Justice Johnson pointed out, the defendant could raise the insufficient service issue then, and we'd have a bad default judgment. And it gets back to the idea that it's been danced around quite a bit here, but the law favors deciding cases on the merits. Here, if this had gone to default judgment, I can pretty much guarantee you that the courts would have said, in the interest of deciding cases on the merit, we're going to set aside the default judgment and go back to the start. As Judge Atchison pointed out in Kuhn, we're now on the opposite of that because of a technical misstep made by us, we're not going to decide the case on the merits and we're going to toss it on a technicality.
I guess I don't understand the technical misstep that you keep talking about. This was a choice that you made as far as serving process. You had to know it didn't comply with the statute. Sure, my understanding is you were trying to avoid disrupting the doctor's practice or, rather than serving him personally, but whatever the reason was, you know what the statute requires, and you knew that you weren't complying with it when you sent the unrestricted certified mail, and you knew that someone, not the doctor, signed for it before he ever filed his answer, asserting a lack of personal jurisdiction. I guess I don't understand why that doesn't factor into what everyone keeps calling a technical defect. It's not a technical defect.
I would agree with you, and I get back to the cases that 6203B was enacted in response to, the Dunn and Bray cases. And specifically, I believe in at least one of those, or possibly both of them, one was a claim against a municipality that was made on the county attorney rather than the county clerk in violation of the rules, and therefore the case was tossed. And we get to why 6203B was enacted. It wasn't done perfectly. I'll grant you that, and in Dunn it wasn't done perfectly either. But 6203B was enacted to save a litigant from a mistake by an attorney where the defendant was notified of the case, proceeded to defend it, and wasn't prejudiced by the lack of notification or the improper notification.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.